Hi, and welcome everyone. We want to thank you for attending our mentor meetup. This is probably one of the largest crowds we've had. So thank you to our speaker, Pilar Nichols, who I have the pleasure of introducing. I've known Pilar Nichols since we were both fellows of the Maryland State Bar Association Leadership Academy, where we graduated for the best class ever. For those of you that have been in Leadership Academy, which I know a few of you are, 2011 remains the best class and best project. Pilar has been president of the Montgomery County Bar Association and the Maryland Hispanic Bar Association. I will not go into all of her accolades because we will never finish, but I want to thank her very much for allowing and providing us this time to work on cross-examination. Pilar, are you ready to take it over?
I am. Thank you, Jessica. So welcome. Thank you all for coming. I can't see most of you. So if you have any questions, I think you're probably going to have to let the powers that be know because I can't see it. So I am I'm the senior partner at Nichols Gelman LLC. We are a small boutique family law firm in Rockville and handle primarily primarily family cases, but we also do a little bit of criminal and we'll do things that are kind of tangentially related. Some of this will sometimes allude to criminal couple things, but this is focused on family. So we'll get started. So first, I want to talk about what the goals of cross-examination are. Okay, so the whole point of cross-examination, right, is to bolster the theme of your case, right? That's one of the goals, right? Your cross-examination should tie in to your case theory, and you should have a case theory. Okay, so there should always be some kind of theory that you're thinking of that is what you're going to go and put forth, right? And every question should be guided to reinforce that theory, right? So if your theme is my client is the more reliable parent, or the other side is lacking credibility, or the other side is an OP means opposing party. The opposing party dissipated assets, and it's up to the court to rectify this issue. So you want to make sure that you're always bolstering your theme so that you don't get that "why is this relevant, counsel?" kind of question. So another thing is depending on where your case is, right? So depending on whether or not you're the moving party or you're not, or whether or not you've had your client already testify or not, right? Sometimes you can use cross-examination to start to take the sting out of things. So when you have a really bad fact, you want to try to take the sting out of it, right? And don't let the other side use it, right, and exploit it, make it be this huge thing, which is what you would want to do in your cross-examination. But sometimes you can backdoor a little bit and bring up with the other party, for example, something that you need to take the sting out, right? Which you would also do on your direct examination if your client hasn't testified yet, and try to bring it out and then, elicit certain testimony that could be mitigating. All right. You also want to elicit helpful facts, right? The whole point is to try to elicit helpful facts and not ones that are not going to help. So you want to get the witness to admit the facts that strengthen your case, the things that are helpful to you, right? You want to, for example, confirm that they were missing parenting exchanges, that they voluntarily gave up, parenting time, that they, have been sending combative correspondence, that they're acting in a way that doesn't foster co-parenting, things like that. And you want to completely stay away in their case, right, in your cross-examination of them, of things that don't help your case, right? Because if not, you ask them these things, you're just giving them the platform, right, to be able to put those things into evidence if, for example, it doesn't later get asked in cross of your client. So you don't want to be the one that brings these things to light. You only want to bring the helpful facts, unless you are trying to take the sting out of, one bad thing, right? So you want to expose their weaknesses, right? You want to highlight their inconsistencies, their exaggerations, or any of the contradictions in the witness's testimony. Okay. You want to undermine their credibility. You want to show that they are biased in some way. You want to show what their motive is for being dishonest, right? People will ask you, well, why would they lie about that? Right? The judge will say sometimes, I don't, I just don't think that he would lie about that. What would be the reason of that? So give them a motive for it. Okay. Um, you want to be able to show whether or not they're unreliable by eliciting that testimony. All right. So these are the goals, right? How do we do this? Right. So um, executing your goals is the next slide, please. Oh, there we go. The biggest thing, and you're going to hear this as a theme for me, is prepare, prepare, prepare. Cross-examination can be a challenge, right? In fact, there's an author who writes a lot of books regarding, trial techniques and things. James, I don't know how to pronounce his last name, McElhenney, Mcelhaney. He writes a lot of these manuals and books and things to be able to help trial lawyers. And in one of these books, he states that cross-examination is generally considered to be one of the most difficult branches in terms of the duties of the advocate. And it is. There's also this kind of uh, tendency at times to say or think that your cross examination is only going to come from what they did on direct, right? And so while in theory, you have to stay within the scope, almost everything, right, in a family law case, right, that's going to be touched upon in direct is going to be in the scope. And if not, you can call them in your case, right? And you still get to get this information. So you should already know, right? 95% of the questions you're going to ask and 95% of the answers that you should receive. You should not be preparing for cross-examination right after their direct, right? Now, we do want to make sure, and we'll talk about it, but you obviously want to make sure that you are preserving or noting what you need to follow up on direct, right? But direct shouldn't be where you are getting the substance for your questions for cross. You should already have that outlined, right? To execute your goal, you also need to make sure that you maintain control of the witness, all right? You want to ask leading questions only. Open-ended questions can end in disaster and leave too much room for these witnesses to start explaining, to start opening the door, right? As we talked about, you want to keep the focus on your favorable facts to your case, all right? You also want to make sure that you are using your objections when they serve you, right? So if you have a witness who is just going off on these tangents when you're asking the correct questions, which is the key there, right? You have to ask the correct question to get the answer or to be able to object as non-responsive, right? When they're not giving it to you. But if you're asking an open-ended question, right? The judge is going to say, you asked him, it was an open-ended question, and you're going to be stuck with that answer. But if you ask the question appropriately, right? It's leading, let's say it's a yes or no question, right? Then you can object and move to strike when it's non-responsive so that that little tirade that they got in isn't going to be there. Witnesses will often try to get in things that they want to get in, right? And they don't want to be, beholden to the constraints of your question. But that's going to just, let them go on, right? And you don't want that. You want to make sure that you are objecting and asking to strike. You want to take command and instruct clearly when asking a yes or no question. Witnesses, especially opposing parties, right? One of the parties, and what I've noticed, their family members, especially their parents, especially their moms, don't want to give you yes or no answers. They want to tell you everything that they feel. And so you have to really take command of it, right? You have to interrupt them. You have to say, sir, it's a yes or no question. If it becomes a pattern, right, you can start incorporating it and the instruction into your question. Sir, were you out there? Yes or no? I have asked repeatedly the same question and said again and again and moved to strike until they answer me with yes or no. And in the end, that's what's on the record, right? So you have to instruct and you have to take command. It's okay. You want to be polite, and you'll see in here that I have, you know, as part of this, remaining professional and, certain ways to address witnesses. But it is okay to interrupt when they are not answering your question. This is your cross examination. You have to take control of it. And if they are going off, it's a yes or no question. Sir, it's a yes or no question. And then all else fails, Your Honor, could you please instruct the witness to answer the question that is asked? And 9 times out of 10, the judge will say, Sir, did you do this? Yes or no? Answer yes or no. And you'll often have judges say, I know you want to give your answer. That's what redirect is for. Okay. Let the judge do that. You want to highlight their inconsistencies. You want to be prepared with them, right? If you had the luxury of having a deposition, which we don't always have, you can, have their deposition testimony and impeach them or note if there's inconsistencies. You want to have any contradictory documents ready. So you want to know that deposition testimony inside and out. We're going to talk about also how to reference it more. But you want to use these tools. You want to use anything in writing that you can impeach a witness with. So any contradictory documents, right? Text messages, emails, right? Any financial records. You want to be able to use these, right? And impeach them. You want to anticipate certain objections, all right? You want to know what your evidence exposure is and what is the likely objection, right? And no matter how well you know evidence, it may at times, right, kind of frazzle you, or you may not know exactly what it is. You want to make sure that it's included in your outline, which we're going to talk about creating an outline in a second. But you want to make sure you know what the risks are of your evidence in terms of whether or not an objection can get overruled or sustained. And if you believe that there's the possibility that it could get, the objection could get sustained, you need to make sure that you can continue to go on and that you can seamlessly jump to your next point without being frazzled that this text message or this email or this document didn't get in. Right? You don't want to have that completely derail where you are in terms of your outline. All right. So the most important thing of cross-examination is preparing for a cross-examination. Next slide, please. So you've got to know your case theory. Obviously, the precursor to that is develop a case theory. All right. And every case, you should have some kind of an idea of what it is that you're trying to put forward. Right. So and tell your client what it is, because sometimes clients, no matter how hard you try, will kind of, want to frame things a certain way, thinking, well, this helps my case. And most of the time it doesn't, right? But you should already have a case theory, right? Going into court. What is it? And that theme and theory should guide almost every question, right? Let's just say your case theory is, my client is the reasonable one. He is hot-tempered and unreasonable. My client is the one that always cares about the kids and what's in their best interest. He does not. He doesn't do any of these things, et cetera, right? So you've got to have this as a theme, and you want to, you're going to bring it out in opening as to what it is. You're going to see that there is a mom here who's done everything, et cetera, or that there's a dad here who does, bends over backwards to do X, Y, and Z, but mom undermines him at every turn, right? So that's what you want to make sure. And you want to make sure that you're outlining to be able to move forward with that case theory. Okay. You really need to know your evidence rules when it comes to cross-examination. You need to be able to, quickly, ascertain what objection you need to use. And sometimes having like an objection cheat sheet is there. Even if it's just what the objections are and you don't have anything else or a definition or anything, sometimes just remembering and seeing it and be like, oh, that's right. Right. And so that's always helpful in terms of preparing and having it ready. But, you really need to, in addition to that, be able to know all of the evidence that is in your case. everything. You have to review the discovery responses. You have to review the depositions. You have to review the exhibits. And not just your exhibits. You've got to review all of the documents, all of them, because the worst thing that can happen is you've got everything that you pulled or that your paralegal pulled or that your associate pulled or you pulled 3 months ago. And for whatever reason, you've got them out here, you use them, they lay out your case perfectly. And somehow you missed, this one email that is a smoking gun, right? Right, that you could use to impeach this witness and would just blow their case out of the water. So you've got to make sure that, you're looking at not just what helps your case, but what hurts their case, right? So you're looking for that. Right. When you do criminal law, right? When I do criminal law, really what you're doing as a defense attorney, for example, I was a prosecutor at one point, but as a defense attorney, your job is to poke holes, right, in the state's case. Your job as a family law attorney is to both put on your case the best way and poke holes in the other side's case. And the only way to really effectively do that is to make sure that you've got all of your evidence, right, that could deal with impeachment or a prior inconsistent statement, that you have it ready and that the most important part, you know where it is when it comes time to use it, right? It doesn't do you any good if you're like, I know I have this somewhere, I read it, but you didn't pull it. You didn't reference it in your outline. You didn't do anything like that. You have no idea where on earth this is in the 657 pages, if you're lucky, most likely, 4,000 pages of discovery in a family case. You want to anticipate the witness's testimony, right? You want to kind of not necessarily, I mean, you don't have to necessarily outline their direct, but you want to know, what are they likely to say? What is this witness probably going to testify to? And you should be able to have that from, discovery, from interrogatories, things like that, right? And you should plan to address, any damaging, testimony that they may or may not say, and then draw out your favorable points. But it's very difficult to prepare for a cross examination if you don't know what it is that they're likely to say, right? And you want to be able to prepare that. You should also be performing a bit of and I say this very loosely, background. You should dig a little bit into the background of your witnesses before trial. And I'm not talking about running a background check on them. I'm talking about vetting them as best you can with the tools you have, right? First thing I do with any witness when I get them is I run them through case search and I do a Google search. Is there anything that comes up? Is anything that comes up at all, right? Do we have a theft conviction? Right? Crime of moral turpitude, which can impeach them on credibility generally, right? Do that. Look at it. You see. Also, talk to your client, right? When you get your interrogatories, attorneys sometimes tend to just review them or the answers to interrogatories, review them and don't, necessarily do too much about it, right? They go and then they use it to determine what they need. They get the information. But what really you should do is send it immediately to your client and say, tell me everything you know about all of these witnesses that are listed. Tell me if you know anything that contradicts any of the things that's listed out here in, your soon to be ex's response to, you know, why it is that she should have, primary physical custody, right? You're, you want to poke and ask your client for anything that could be the slightest thing that they could think of that could lead you to something to help. Okay. Those are the things that are going to be the best gotcha moments on cross examination because it's not something that the other side is putting forth. So it's not necessarily something that they are going to be trying to highlight, but also sometimes they aren't aware of it. The amount of times I have impeached a witness with a theft or burglary or something like that conviction, and the other side, the attorney that put them on, had no idea because they didn't do any vetting of their own witness. It is definitely one of those moments that's, worth the price of admission. But you don't want to get caught in that same situation and you want to use it to your advantage. You want to have, and I'll talk about this a little bit more, but you want to have a trial binder. But the biggest issue is you want to make sure you have a question outline. You should have an outline for everything that you are doing. People seem to think that, the more seasoned you are, you don't need an outline. Absolutely not. I've been practicing for over 20 years and I still have a very detailed outline. Um, it not only helps me and keeps me to where I was and make sure that I hit all my stuff, it helps prepare your client if you're doing it in direct. So for cross exam, right? You're essentially thinking, what is it after you've outlined, what you anticipate that they're going to testify to, and then you're going to go and outline what are the questions to elicit any issues. You want to make your cross examination questions as short as possible, and you want them to be leading questions. Okay. You want to make sense when you are, saying doing your cross examination. Now, there are times where you will go out of order or you'll jump around. Usually, I have my outline. I go through my outline and cross, and then I'll go through my notes from my, what I took from them on direct, and say, now I'm going to jump around a little bit, just addressing some of the things that you said in direct. But I will do my stuff first because most of it's already going to be addressed in there, right? Um, but you should, to the best of your ability, group your questions by topic when you're doing cross exam. And so you can go boom, 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 right? So if you need to, talk about the divorce merits or talk about finances or, parenting, credibility, put those all in chunks. Okay. Um, I prefer this, generally speaking, over a complete chronology. Sometimes, like at the very beginning, I will do a bit of a chronology, but it's a lot easier and quicker, and you're going to get answers much faster if you're grouping things in topic versus trying to have people remember through all of the timeline. All right. Your outline is very important, but you have to be you have to be ready to stray. You can't be dependent on your outline, right? It could be, you have to figure out at one point in time, right, what can be cut out if you're running out of time, right? You also have to be able to pivot when testimony gives rise to to like an impeachment question or another question that's not in your outline. All right, I tend to just kind of write it down, or I'll put it in my in my notes from direct as to what I'm going to ask. But you should, be prepared to stray from it. Also, if items have already been asked that are not in controversy or that helped you, there's no reason to ask that question. Um, in your outline, you should be noting the bait stamp numbers of the records that you want to have, right? And you should have those pulled. If you think someone's going to lie about something or somebody already lied and you're going to go into a line of questioning from a deposition, for example, right? You should have in your outline the deposition page and line, right? And a reference to it, right? In your outline. So, the question is, for example, you went out that night, correct? Right? And then you'll put on there here, depot answer didn't go out, 15 comma 2, right? But you should make your outline work for you, meaning it helps you identify what document you need to pull quickly, right? And I put my exhibits in order, right? I do my cross exhibits, I have them in a separate pile, and I put them in order as they go in my outline. So I will number them, and I just number them, you know, 1 to whatever. I don't try to anticipate what the exhibit number is going to be, right? Especially if, I'm not the moving party. But you number them, and so in your outline, it should say, right? I put them in red in bold letters, exhibit 1 and what it is, right? Where you're going to do it. Okay. And then, it'll draw your attention. You'll have it and you know what number it is. And my suggestion would be use either bankers boxes with folders or use the Red Will files. Something there's also, like the plastic ones, depending on, the plastic little tubs, depending on what it is. But if you have them lined up and you have them all sticking up, right? And you have them clearly marked, right? I usually use one of those like fine tip Sharpie markers, right? Because they're bolder. And I do it in like purple, right? But 1, 2, 3. So you can just go, your outline says, you know, deposition or, whatever, email from 522 says this, right? Number 5. you're going to go, poop, 5, here you go, right? And of course, they should all be ready already in triplicate and, you know, all set. But that is going to make things much faster and more effective. All right. Um, there You also, by the way, may have I always have a ton of exhibits that I end up not using because I want to anticipate, and you should anticipate, if you're going to ask a question that you may need to refresh the witness's recollection, right? If you're asking for numbers or dates or something. Also, sometimes they will pretend not to remember, right? You wrote him and told him that he was the worst father on the planet, didn't you? I don't recall that. And you're going to have in there, right? Exhibit, email 1022, right? And you're going to show it to her. Does that refresh your recollection? Yes, yes, it does. Right. So this way you've got it on there. You're not rifling through papers, right? You're not irritating the judge, but more importantly, you're not breaking your groove, right? You don't want to give these pauses to the to the witness that you're cross-examining because this just gives them more time to think of ways to get out of your question. Okay, so you don't want to break your groove, and not breaking your groove, right, requires the utmost of preparation, right? Um, so let's go to kind of when we're there, structure and technique, right? So if you could do next slide, please. Okay, structure and technique. So leading questions, right? I know I keep saying this, but you really want to essentially pigeonhole them into what you want them to say. A leading question should presuppose the answer. You dropped the child off at 9:30, correct? Right? Don't say, "Well, what time did you drop off the child?" Well, it gives too much time to move, right? So I think that you want to make sure that you are asking very direct questions. The goal of cross-examination is to get in what you want. The goal is not to let the witness talk more. It is to get the pieces of evidence that you want in. And to do that, you need to tailor your questions and have them be leading to be able to do it. All right. You want to start strong and end strong, right? Theories of primacy and recency, right? You want to begin with some points that immediately there'll be some points of concession where they can't you know get out of what they said or what they did or some kind of some kind of action. You want to start strong, all right? And you start going right away and the judge starts, oh, okay, I'm starting to see this, right? You go in and then at the end, right? You want to save your strongest impeachment if you have it, right? Or your favorable, most favorable admissions for the end. You want to end on a high note. Okay. And so I always save those impeachment at the end. Also, that way they just had a whole God knows how long testimony and you just caught them lying. And the judge is like, well, basically nothing. Right. So depending on obviously what the impeachment is. But, this is something that, you want to make sure that the first thing and the last thing the judge hears is helpful to your case. And this is especially true if you're going to end up with a break in between. Right. Um, you want to control the pace of how you're asking questions. So you want to get one fact per question, right? You already know you can't, you shouldn't ask compound questions. They become confusing. It leaves room for too much talking for the witness. But the goal should be one fact. It should be boom, boom, boom. When you think about what a transcript should be, right, for a cross examination, it should be basically bullet points: question, answer, question, answer, right? And it should be, your question, your point you want, your question, the point. All right. You want to make sure that you are asking very short and clear questions because you don't want the witness to have to explain their answer, right? It's very hard to justify saying, well, uh, can I explain, or I want to explain more, when the question is very clearly a yes or no question, right? So you dropped the child off at 9:30. Well, I mean, the problem was yes or no? Yes, right? So that's why you want to keep it very short, very clear, right? You want to make sure you're listening to the answers that are given. right? Sometimes people get so focused in asking a question and being ready to ask the next question that they're not listening to everything the witness has said. Okay. In my outlines, I write a question and I anticipate an answer, right? Not written out form, but in bullet points, right? And either yes, no, or whatever I think they're going to say. If it's something completely unexpected, right? I need to be, and you need to be ready to pivot, right? And explore that more and go off script, right? If you haven't already accounted for that, if it's something completely out of left field. You want to make sure that you're using your impeachment tools appropriately, okay? Um, Prior inconsistent statements, use the deposition transcript, use correspondence, right? Contradictory documents. You want to introduce exhibits strategically, okay? If you have a chunk of emails that all call him, call the opposing party an a-hole, right? And you're like, you continue to do this with him, right? You want to put all of those in one packet and say, this consists of, what is this? How many emails is this? 17. And in all of these emails, you call him that. That's going to be much more powerful and a lot less annoying that if you go one, and then here you called him this, and here you called him this, and the judge is going to start to go, oh my God. All right. And so, but when you're talking about something voluminous like that, introducing them, strategically is important. This is also why summaries are important. So when you're introducing, for example, if you're trying to point out some inconsistencies or some dissipation of assets or something, right? You have the binder, right? That you have, for example, or the chunk of bank records, and having an outline, or excuse me, a summary, which of course you filed notice pursuant to the rule, right? To introduce those, that's going to be very helpful. It's going to be able to show the judge what you're looking at, right? It's going to save you time because you don't have to go through every single one of those and you can introduce it, right? Now, you also want to reveal any conflicts of interest. You want to show any of their biases or motives, right? There's ulterior motives, right? Did they get into a fight with the opposing party or your client at one point in time, and now he's looking for revenge, or is he now dating the opposing party? Things like that, right? You also want to make sure that you are staying calm, professional, and respectful, which is not always easy to do in cross examination, especially when you feel the other side is lying. And especially when some of the objections haven't gone your way and you don't feel that you've been able to get what you wanted to get in. But really, it's going to be, sometimes the difference between the judge continuing to listen to what you're saying or kind of tune you out. They don't want to see, bickering between attorneys. They don't want to see somebody, going after in a really ugly way a witness on cross. You want to make sure that you're doing it professionally. So I want to give you what we're going to take this down for a second. I have some more slides, but I want to show you two video clips. All right. And I want to show you the difference between, being able to, use your questions as you need them, right? Or as, you want them to come out, right? And how, control of the witness can be so important and how it can make such a difference, right? So I want to show you the first one now. The first one, just full disclosure, is a criminal case where the man is representing himself, but he was an attorney. Okay. But he was representing himself. So he's asking, he's doing a cross examination of the complaining witness, of the victim in the case. So I want you to watch this one first. Go ahead. You can't hear the sound, I don't think. I can't hear the sound.
I'm asking you specifically, before we had sex, did I threaten you or force you to have sex with me?
My answer is yes. You forced me to have sex with you.
Did I hold you down?
No.
Did I push you?
Not at that time of having sex, but prior to having sex, you did push me. You did hold me down. You did tie me up. You did attack me, and you did break into my home when I was sleeping. You raped me.
So you're calling it rape?
It is. That is the definition of rape. To come into someone's home and attack them and tie them up and then have sex with them. That is the definition of rape.
Did you know I was coming to your house?
Okay. So he started off, right, with yes or no questions, but then it all got derailed. If you see, he ended up asking, he lost control on a yes or no question. Okay. He asked a yes or no question and didn't object and allowed, right, for her to continue on and say very damaging things to his case, right? So at that point, right, he now is kind of losing control of the witness and he's probably getting frazzled, right? But that was the first point where you can lose control, is when you don't take command back, right? Witnesses will try to control it, but take command back. And then, right, he asked an open-ended question. He went off and got that is an extremely damaging statement that she made. And he completely opened the door to it. And so that was, a way, basically an example of losing control and not sticking to asking leading, presupposing answer questions. So now I want you to see this other one, which is actually, for some of you may have seen it already, it is actually a very small portion of the cross-examination of Amber Heard in the Heard Depp trial. If you could play that.
Hey guys, did you know some drivers are ditching their car insurance and they're doing this instead?
Sorry about
On
that.
her claims of abuse.
That either he has the bottle before or after he's holding you by the neck on the counter. Is that your testimony?
He held me by the neck on the counter.
Where's the bottle? That he
At
assaulted
what
with?
point?
While holding you down by your neck.
When he was assaulting me with the bottle, it was in his hand.
Was it in his hand before or after he holds you down by your neck?
I was being held down while he assaulted me with the bottle.
When he puts you on the counter, does he have the bottle in his hand, yes or no?
As I have always said, I don't remember exactly what happened first, or I don't remember the sequence. I just remember being aware that I was being assaulted by a bottle while I was on the countertop.
So he penetrates you with this bottle. But you don't know how he got the bottle, right?
That is correct.
And he did that right after he lost the tip of his right middle finger.
Again, I don't remember the exact sequence of those events.
We'll get to the sequence. And while he was on 8 to 10 MDMA pills, right?
Yes.
You testified this is the picture you took after that incident, right, Ms. Heard?
Yes, that was one where he grabbed me.
And hit you in the face so many times that you don't remember. Isn't that correct?
That's correct.
And there's no injuries to your face in this picture, are there?
Not that this picture shows.
And there's no medical records reflecting that you sought treatment after this alleged incident either.
I did not seek medical treatment at this time.
So there's no medical records reflecting any injuries to your face after he hit you several times.
I did not need to go to the doctor at the time.
There we go. Back off mute.
I believe
When this first came out, people were talking about how incredible this cross-examination was of Amber Heard, and it really was stellar. And if you notice the things that she did, right, she kept such control. So the first is, if you notice at the beginning, she asked her, did he get the bottle before or after? And then she kind of tried to do her own answer. She asked the question again, but slightly differently, right? To get the answer, right? And said, right, when he put you on the counter, did he already have the bottle in his hand? And she instructed, yes or no. right? She also used her previous words from her testimony against her, right? Hit you so many times that, right? Use that. She used pictures, right? A picture to impeach her, right? With leading questions. And she also used the absence of evidence, right? When someone, claiming an injury, but there's nothing here to your face, correct? And so there's no medical records, correct? Right? That is the way that you can control the way that the witness is going to answer your question. And what ends up happening is when you get them in this box of having to answer one way or another, oftentimes if they know the answer isn't favorable to them, they will default with I don't know, or I don't remember, or I'm not sure, which immediately, depending on what the issue is, right? If it's something so, that you should have this knowledge of, immediately causes credibility issues. Well, you were definitely sure before, but now you're saying you're not sure, right? You just have a witness who's unable to admit, right? Or doesn't want to admit bad facts. So next slide, please. I chose those two clips specifically, obviously one because one was, better and the way you should do it, but most importantly because even though one is a civil trial and one's a criminal trial, they deal with issues that we see a lot in family law cases, right? So you can go back to the other one, to the previous slide. Yeah. There are special considerations in family cases that we see, right? That aren't always in other cases, right? We don't have a jury, right? So this is very different than criminal. Criminal has a whole different type of strategy, right? And so does civil in front of a jury, right? Because there are times where you want to limit certain things that you say and how many times you object and things like that to not give the wrong impression to the jury. We don't have that, right? We don't have that issue. We also have the one overarching issue if you have a custody case where the standard is this best interest of the child, right? And one of the things that you have to remember all the time, right, is despite the fact that you're trying to advocate for your client and put forth your case theory and try to get the best results from your side, you have to remember that custody cases are about the child and not the parent. So the questions that you ask should be framed in that way. So the question shouldn't be, right, and because and you said she couldn't go, correct? Correct. And because of that, dad didn't get to take little Susie to the amusement park. No one cares about dad, right? You said no, correct? Yes, right? And because of that, Susie didn't get to go to the amusement park. And she didn't get to spend some time with her dad that day and make memories, did she? Right. I wouldn't put the make memories part. But, if you make it about the child, right, that's going to make it much more focused, going to be more impactful. So you've got to remember that you always want to phrase it as, about the child. It's not about the dad or the mom losing parenting time. It is about the child losing parenting time with that parent, right? You want to make sure that you're keeping the questions focused on parental conduct, right? And the effects of the child, right? So, for example, right? And, that the parent did XYZ and you need to tie it to the effect. So, you got mad at him because he wouldn't do XYZ, correct? Yes. And because of that, your daughter didn't get to go out with her dad, right? You want to tie what their actions are to the effect that it has on this child. You're going to deal with a lot of sensitive topics in these cases, right? You're going to deal with substance abuse, right? Domestic violence, mental health, right? Sexual assault, right? So with substance abuse and with all of these, right, you want to ask factual, non-judgmental questions. When you're trying to talk about substance abuse, right, you want to talk about dates, right, of certain incidents, treatment efforts, test results, dates of admissions, programs, right? You want to ask them factually and non-judgmental, right? A judge will stop you from certain cross-examination questions if they think that it's getting to a point where you're just, harassing or trying to make them feel embarrassed. And even if you're not trying, if you're asking the questions in an insensitive way like that, a judge isn't going to like that, right? And it's not going to get you the answer that you want. Domestic violence, right? You want to handle them carefully. You want to handle them sensitively. You want to make sure that you're keeping the questions narrow, fact-based, right? And that when you're cross-examined, well, and you said that he did XYZ. Yes. But you never reported that. No. And you didn't tell anybody that this happened. No. Right? You never ask why, right? But these are the kind of things, but you want to make sure that you're keeping them, right? Fact-based, right? Mental health, right? You want to stick to the most objective facts, right? What are their diagnoses, if it's relevant, of course, right? And we have, case law that says when it is and isn't relevant, right? Are they compliant with treatment? Is there documentation to show that they're not? Are their actions impacting the children? Is it affecting their parenting? Right. So the whole thing is, you don't want to go in there and basically just say dad's crazy. You want to go in there and say dad has some untreated mental health issues. He refuses to get him treatment. And this is what's happening to the children and the effect on them as a result. Right. With self-represented litigants, right, you want to maintain courtesy, even if they're combative. They're often emotional. And you need to make sure, because you're going to be cross-examining them and they will have given their testimony, right? But also with any witness, you want to make sure that you're phrasing questions clearly, avoid legal jargon. All right. The less you get of, I'm sorry, I don't understand your question, or can you repeat that again? The smoother your cross is going to go. There are emotional dynamics, right, in family law cases that there just aren't in other cases. You're going to have to anticipate some emotional outbursts, some tears, things like that, right? And you're going to have to anticipate, right, that a judge is going to be a bit sympathetic and be like, oh, would you like some tissues? Would you like this? Would you need a break? You're going to have to anticipate those things, right? And so you want to make sure that you are structuring your line, your line of questioning in a way that potentially could allow for these, right? You also certainly want to avoid appearing to provoke or, trying to exploit what's happening, right? You want to have somebody act a certain way depending on what they are, right? So you have somebody who's, short-tempered and you're like, on the deposition, they got mad really easily. You do what you need to do. You ask the questions, but you ask them in a way, right, that's professional and that elicit the response you want without, seeming, disrespectful. I'm going to try to hurry because I'm almost out of time, but just some practical tips to consider. Next slide, please. Your question should presuppose the answer, right? You missed 3 exchanges last month, correct? Right? You didn't notify the other parent before missing those exchanges, correct? Right? They should give the answer you want. You should be asking for an affirmation of what you want in, right? So, a lot of that, if you can just keep them steady, right, you're going to get in everything that you want. You have to know your rules of evidence. You have to know how to impeach people with emails. You have to know how to impeach them with text messages. You have to understand hearsay and how it affects correspondence. If there's hearsay in your documents, you want to redact them ahead of time to avoid the objection. You've got to really understand the difference in hearsay when you're using party communication and whose communication is admissible and what qualifies in that instance as hearsay, because something that could qualify as hearsay in another situation isn't necessarily being offered the truth for the matter asserted, for the truth of the matter asserted at that time, right? You want to make sure you're referencing your exhibits and your outline so you know where they are, right? You want to use a note-taking method on direct that works for you, right? I do a split note page, right? I used to do it on paper, now I do it on a computer, but I put a chart. I take all of my notes on the left side, then I tab over when I want to ask a question and I put in there what I want to ask so that when it comes time for cross, I have my notes, right? I do my outline. I ask for court's indulgence for a second, and I just have to go down that column where I pointed out what I want to ask. I don't have to go through all my notes again, right? And so it can be just a small column, but you want to go and that way you can tab it. You don't have to write out the question. You can just write, ask about this or do whatever, but it flags you, right? Prepare, prepare, prepare. Well, last things I'll tell you is I think that, well, a couple things. The first is have a trial notebook. I have I have the statutes. I have the copy of all of my outlines Okay. I have in there, evidentiary rules, things like that. I'll put in all of the important pleadings just to have at my fingertip, the, initial complaint, the, motion to modify, whatever it is, right? Also make sure you're paying attention on direct exam of the witness you're going to cross, right? There's, there's times where I've seen people open the door, right? When a witness testified, it was helpful to their client. They asked them the question in a different way that allowed for the witness to almost fix the testimony. So you're happy with the evidence that got in, leave it, right? And then the last thing I'll just tell you is quit when you're ahead, right? When you get what you need and you have done it, don't ask one question too many. Don't browbeat or be, sneering or sarcastic. You don't have to beat everything to death, because the judges are just trying to get the information, and you don't want a judge to inside their head be going, okay, we've heard this, right? Avoid asked and answered questions, right? And don't ask your question twice just to emphasize the importance. It's not helpful, and it doesn't have the effect that it has. In fact, judges will tell you it really irritates them. And that's it. Oh, and don't ask any questions you don't know the answer to. But I think that's a law school 101, I think, that we all go by. So,
Well, we have a few minutes, and folks had asked some questions in the chat. One of the questions is, what is your advice if opposing counsel objects to almost every question to disrupt your flow or gives speaking objections to lead their client?
it happens a lot, unfortunately. At some point in time, the judge is going to sneer over and kind of say, we're going to have a problem. What I have done before, especially when we have a situation where the judge is keeping time, I have definitely said, Your Honor, I just want to make sure that counsel's objections are counting against their time, as they seem to be, more frequent than expected. And I smile. And typically that gives them a little bit of an indication. Other than that, you don't want to show them that you're getting frazzled, because if you do, they're going to do it more, right? And so I would say first of all, if the objections are getting sustained, then I would say you need to look and make sure that you're asking different questions. But if they're getting overruled, it will typically naturally handle itself. But yeah, I usually say to the judge, I just want to make sure it's counting against them, right? And I have objected and said, Your Honor, if I could please object, and if we could please ask counsel not to do speaking objections, that would be appreciated. That's what I do.
How do you manage referencing your outline in the presence of a jury? Does it make you look inexperienced?
No, I don't think so. I haven't had a jury trial in probably like 5 years now, maybe. Yeah, a little less. But no, I don't think so. I think a jury, just like a judge, appreciates organization and appreciates when you're going boom, boom, boom. I also use my outline as an outline. I don't use it as a script. So I put it there. I'll go back. Sometimes I'll ask questions, right? And I'll know kind of where I am in the outline and what the questions that I'm asking are, at least the general idea. And I could ask a couple of them when I put my outline down, but I'll check them off. I've never had an issue with anybody, doing anything or having a negative connotation with an outline. In fact, I think it makes you look prepared. I actually find it interesting, and kind of ask myself, what are you doing when you have people who are in these 4 or 5 day trials and they don't have an outline? I just don't know how you're really keeping track of that. I actually think that doing a proper outline is something that you learn as you start getting more seasoned. And I think that it's a very useful tool. So it's never been something I've been worried about looking inexperienced about, especially because I'm going to look inexperienced if I'm rifling through a bunch of papers and I forget to ask the questions that I need to ask. Looking prepared and organized is never a bad thing.
If you exchange your exhibits that you plan to use prior to the hearing with opposing counsel pro se party, do you still find it necessary to bring a copy of the same exhibits to court for opposing counsel or opposing party?
You mean if you sent it over to them as in an email as attachments and in advance?
I believe so. I believe that's
Okay.
Yes, that's what.
Okay. I always do. I usually print out, depending on if there's a BIA or not, right? I usually print out 4 copies of everything, unless it's something incredibly voluminous. So unless it's like, 2 years worth of bank records that I'm doing a summary for, which I'll put in a binder. I'll put the summary on top. I'll introduce that and I'll tell counsel in advance. But more often than not, I will do 4 copies, especially if they're emails and things that need to be looked at. And I will do 1 copy for the witness that gets marked, 1 copy for opposing counsel. Obviously, if it's the same witness, you don't need that one if it's their pro se. I do 1 copy for me to have and mark what it is, whether it was admitted and have in my pile. And depending, what it is, if it's something that I want someone to follow along with, I'll bring a courtesy copy for the judge. So I'm there with it with 3, sometimes 4, but I always bring them whether I exchanged them or not.
What's the best way to stop a witness who's going off beyond the question?
Objection beyond the scope. Or objection, Your Honor, at this point, we're non-responsive. So the judge doesn't want to hear them go on and on and on and on. But you can't just say, okay, stop talking. So you can just use those objections. I mean, sometimes, just non-responsive or, Your Honor, at this point, the witness is not, answering the question. There's no question pending, things like that. So this is why it's helpful to have them on a little cheat sheet to make sure you're using them.
Well, if we do end up having more questions, feel free to email me your questions. I'm sure Pilar would be happy to answer them. I will make sure she gets them and I will follow up with her to make sure she answers. But at this time, I think we're at time and I really want to thank everybody for attending. I specifically want to thank Pilar for your time and your effort on this. We will share the presentation. I didn't ask you, but I'm just going to go ahead and assume that's fine. And as you can tell, Pilar, one thing I forgot to mention, Pilar is a lecturer at Catholic University. She's one of the professors and she teaches what's probably going to be changed to managing and starting your own law firm. So if any of your friends are at Catholic, they can always take a class with her. And she's been teaching for
15
the
years?
last 14 years. And unfortunately for her, she gets to teach it with me now, but I will be able
I
to.
sucker Jessica into it.
So if anyone has any additional questions, feel free to email me. Thank you so much. This was really helpful and we really appreciate your time and energy.
Thank you for having me. I appreciate it.
Thank you so much.
Thank you.
Thank you. Bye, everyone.
Bye.